Good morning, guys. I hope you guys are doing okay. Welcome to the second edition of our series of clips on everything that has to do with law. So here you are today talking law matters with Hassan. And today's aspect is very important because now it's applicable to basically any student who is dealing with law issues. It could be your higher certificate in law from UNISA, it could be your diploma, it could be your paralegal studies, it could be your LLB, it could be your BA in law. As long as it's law related, this is for you. So I urge you guys to listen attentively, take notes where necessary, play back the video over and over again where you don't understand. So basically today we're dealing with the heartbeat of law. This is the heartbeat of law in the sense that law is about cases. So you realize that there's a judgment that can contain close to 200 pages. And as human as you are, that's impossible. There's no way that you can memorize 200 pages of a judgment for an exam. So you have to find a way of summarizing the whole case from trimming it down from 200 pages to a page or to a page and a half, or even to half a page. It's very possible. But now we have to master this art of analyzing and summarizing cases. It's actually an art. It's a science. The more you practice it, the more you become perfect. But you will never become perfect a day before the exam. No, this will start now. And this is the reason why I had to upload this video, because it's going to make life way, way, way easier for you. Because there is no way in exam that they won't expect you to have to refer to case law or to authority. So remember, the Firac method basically is made up of 5 steps. So each letter of the abbreviation Firac represents a step. So we have Firac, that is Firac, which are 5 letters. So those 5 letters actually represent steps. So for the Firac method, just remember that you have 5 steps. So if ever you want to use the Firac method and then you have 3 steps or you have 10 steps, then automatically you are wrong. There should be 5. Not more than, not less than. Basically that. So I'm going to take you guys step by step. So the first step number 1, are the facts. What is the summary of the case? That's basically that. Give us the background. What happened? What is the story behind? Who did what to who? How? Where? When? You understand? Suppose there was an accident, maybe somewhere around. Now you have to tell us that A was coming from this direction, B they was coming from this direction. So A bumped into B because he skipped a red robot, and then he bumped into B, and B's car was damaged, or the window screen was broken. So that is basically the story. You don't really have to tell us the place or the time or the date, no, or the names of those people involved. You can actually be able to refer to them to be as plaintiff or plaintiff or respondent. You understand? As easy as that. You don't need to remember all the names. Now, you also need to give us a big background about the case. Remember, there are some cases that they start from the magistrate's court and end up at the constitutional court. So it doesn't make sense for you to just give us this background, these facts from the perspective of the constitutional court without you telling us that actually this case actually emanated from the magistrate's court. From the magistrate's court, it went to the high court. From the high court, it went to the Supreme Court of Appeal. From the Supreme Court of Appeal, then it ended up at the constitutional court. So you involve all these things in the what in the facts. It's basically the background. What happened? Don't give us dates. Don't give us names. You can still refer to everyone involved as respondent and plaintiff. As easy as that. We move to I, which is our step number 2, which is basically our issues. And Other textbooks, other people refer to that, to step 2, as the legal question. So what is the dispute? What is the dispute? What is the dispute? What's the fight all about? What is the fuss? Why are we here? What is it that the court is trying to solve? What is it that the court is trying to determine? So, giving the example of the car accident, now we have to determine whether A is liable in delict for bumping into B's car. Is A at fault? Does he carry liability delictually for whatever that he did? That is the real legal question. So now the court has to decide whether A is liable or not. Basically that. That is the dispute. Easy, guys. Easy. Not complicated at all. So once you have the dispute, you have your legal question. You have your issues. You are done. You are smiling in the exam room, or you're busy with your assignment. You're smiling. You're taking note of these things. And they're so easy because Hassan once talked about this. You understand? So from there on, you move fast. Step 3. What is it? You talk about the rules of law. You understand? The rules of law. Now you're talking about the rules of law. You're like, okay, what does the law say about this dispute actually? We have rules and regulations. So what does the Constitution say about this dispute? What does the legislation say about this dispute? We have the common law. What does the common law say about this dispute? We have customary law. What does customary law say about this dispute? We have case law. Okay, in the case of S versus S, the court, the judge actually said this. So what does the law say? What are the rules saying? So you don't necessarily have to refer to the Constitution and try to force things. No. If you are talking about human rights or constitutional rights or fundamental rights, obviously you have to make sure that you include them, because you cannot talk about fundamental rights without the Constitution. You can talk about legislation if it's applicable. You can talk about the common law if it's applicable. But don't force things. From the example that I gave, you might not find any legislation that is applicable for the car accident, for delict, because delict is actually a remedy. It's part of law that is regulated by the common law and case law. So you might not even refer to the Constitution or the legislation. You rather refer to the common law and your case law. So that's basically that. What does the law say? What are the rules saying about this dispute? What is the legal framework? What is the legal standpoint in terms of car crashes in South Africa, in terms of delict? Remember, it's not a criminal matter. We are taking it from a delictual perspective, where the guy wants compensation for where B wants compensation for the car that was damaged in the accident. You are smiling. Now you move to step number 4, your application. Now you simply apply the rules to the legal question, guys. Look at the legal question and then basically apply the rules. As easy as that. You have your rules already. You have your legal question already. What is happening? The legal question is A delictually liable for damaging B's car? What do the rules say when somebody bumps into someone's car and damages it? What are the rules? The rules say B should be compensated for the losses that he made, for the damages that he's going to make. Remember, B has to go and fix his car, so he has to be compensated because A is the guilty part. As easy as that, guys. Those are the rules. That is the legal question. Those are the facts. You marry them, you bring them together into one, and you're good to go. You have applied. You're smiling, guys. You're smiling. Now you're going to the very, very last step. Now this is the conclusion. Step number 5. What would be the court's judgment? Remember, this is a typical case scenario. This is a real case that could happen. What do you think the court will say? Is the judge going to find A liable for the damages or not? Is A going to get away with everything? What is the court going to say? What any other recommendations can the court say? And there's a catch. Even if your conclusion is wrong, it's still okay, because usually the conclusion is only about 2 marks out of maybe 10 marks. The huge chunk of your marks are coming from the rules. So once you have mastered the rules, you know that you're set for life. You're good. You understand, guys? It's easy as that. 5 steps. You follow them in that order, and you will be smiling all the way, guys. This is not rocket science. Absolutely not. And now you need to make sure that you practice it. The more you practice it, the more it becomes automatic. It's like driving a car. You can only perfect by actually doing the actual driving. So when you see a case, take it, look at it, play around with it, summarize it. You understand? And to put this into life, to put whatever that we'll be talking about into practice, I will later on upload the S versus Makwanyane case on Facebook, on my Facebook timeline. And I'm going to do it nicely. I'm going to analyze the way that I have been explaining here. So for those who are following me on Facebook, you're good. I'm going to do it by the end of today, Saturday, so that you can actually find the practical side of whatever that we've been talking about here. And if you are not friends on Facebook, make sure that you look for Hassan Tendai on Facebook, and you can follow everything law related. You understand, guys? So the more we practice, the good we be, the better we become. And guys, remember, this channel is your channel. You are the owners of this channel. You tell me what you want to hear. So make sure that you subscribe, you leave a comment, and kindly invite your friends and their friends and your family members, because this forum is not only about LLB students, because at some point we'll be giving legal advice. It could be your labor law, it could be anything. It could be on how to what to expect when a will is being drafted and everything. So make sure that you tell your friends, you tell their friends, you tell your fathers, your uncles, your mothers, your sisters, your aunties, your nieces, your cousins, and everyone. So thank you guys for listening to this part, and we'll catch up again next time. Take good care of yourself, be productive, work hard, enjoy the Firac method.